Welcome back to my channel. I hope you found the previous one informative. Please subscribe, like and share. So today I'll be giving you an overview on maintenance as provided for in the legislation with a little less sarcasm and an interesting case regarding duty to support. So child maintenance is a liability of biological parents to financially support their children who are unable to financially support themselves as set out in the Maintenance Act 99 of 1998. And it is directed at the enforcement of the common law duty of the child's parents to support the child. The Act states an amount that is fair and reasonable according to their respective means. Now, as you can hear, that is so broad. This act is meant to ensure that the child is protected until they're independent and self-supporting, and that both parents honor their duty to maintain and support their children. So even if one is still in a relationship and a parent is not contributing, one can approach the courts for a maintenance order. However, the normal scenario is when relationships end and parents approach the court for a court-ordered maintenance agreement. According to the Divorce Act 70 of 1979, a maintenance agreement and a parenting plan is required to form part of the divorce agreement. One can apply for Rule 43, which is an interim maintenance and contact order made in High Court, or Rule 58, which is a regional court application for an interim maintenance and contact order until the divorce is finalized. Because often, the first thing that happens when a relationship ends is finances are cut off or limited. So this amendment was made to protect the children. The first duty falls on the parents. If the parents are unable to pay, then the duty falls on the grandparents or the person requiring maintenance's siblings. So obviously the siblings will have to be earning an income. So we're probably talking about adult people who still require financial support. This is often a very contentious issue, and people respond by saying, but the grandparents were not there when they were making a baby. No, they were not, but they are bound by the duty to support. But it also works the other way. Grandparents can claim from their children, so as they get older, they might need financial assistance from their children, and they would follow the same process. They would submit an application to the maintenance court for maintenance from the children. Doesn't happen often, but it does happen. So first, it needs to be established by the courts that the first person responsible, the biological parent, is not able to pay. Only then will they attempt to establish if the grandparents can pay. They then summons both sets of grandparents, but normally the maternal grandparents contribute in one way or the other because children are primarily being brought up by mothers. So a maintenance order is made between the parents. Should the father not earn sufficient to cover the needs of the child according to common law, his parents can't be ordered to pay the balance to make up the total amount required to meet the needs of the child. The same applies should a person fall into arrears. A claim for the arrears cannot be made against another person. So you can't have two orders, one order made against two people. Sorry. So here's an interesting case while we're talking about that. The respondents in this case were the maintenance officer, the mother, and the magistrate. So that tells you something. Case number 31156/2012, a Rule 43 interim order was made, which was defaulted. The second respondent, in this case the mother, had approached the court in January 2012 due to the father not adhering to the order. There appears to be some issues regarding serving of the summons, and the criminal case was withdrawn against the father of the child. The mother lodged a claim against the respondent in this particular case, the grandfather, in May 2012, who was called upon to appear in court in July 2012. There appears to be a few contraventions of Promotion of Administrative Justice Act 3 of 2000. That's the right to administrative action that is lawful, reasonable, and procedurally fair. Section 33(1) of the Constitution. There was an existing order against the father which had not been set aside because the court had not established that the biological parents were unable to support the children, and therefore a directive could not be issued against the applicant, in this case, which was the grandfather. So they agreed, all the respondents in this case agreed that they would abide by the judgment in this case against the applicant, so that the case be withdrawn until proper procedure had been followed. And you know, this happens far more than we'd like to believe. Regulations are flouted regularly. And as a layperson who doesn't understand the law and can't afford an attorney or an advocate, if this happens to you, you have to follow protocol. And you complain to the appropriate person and then complain to the next until you get a response. Even then, you might still have to complain further. And that's what's so important to understand the Maintenance Act. Can't emphasize that enough. A common myth is that one can claim child support from the ex-partner's new wife. This is not the truth. As I've previously stated, the biological parents are duty-bound to support their children. However, if they are married in community or property and the person whom the order is made against defaults, and the person whom the order is made in favor of lodges a failure to adhere to a maintenance order complaint, an attachment order can be given against the joint estates. So this means that the sheriff of the court can attach the goods and sell them to cover their arrears, just like any other civil debt. But I do need to make you aware that should one pursue this route, you will be required to cover the sheriff's fees and any storage costs incurred. This amount is added to the arrears total, but you have to outlay the costs to recover the arrears. I will dig a bit deeper into this later in the series, because this is very contentious. You don't have money. They're in arrears, but you are still required to outlay the money. So there are some links in the description pertaining to duty to support for easy access. I find High Court cases very interesting and very informative. Safely is a fantastic site to find cases. Their link is also in the description. So thank you for watching, and please remember to subscribe.